On Christmas morning 2024, gas station employees
I swear to God, you're so happy. You got nothing to keep going.
Business that they don't have to do. I'm gonna write you a notice to appear for disorder. You told me to give it to you straight. You wanted to 25. Answer for the charge of
On the morning of December 25th, 2024, the fluorescent lights of a Champaign gas station hummed over a quiet holiday shift. Most residents were home opening gifts or sleeping in, leaving the streets of this Illinois college town largely empty. But inside the Circle K on East Green Street, the peace shattered in seconds. A woman stormed through the glass doors, bringing with her a chaotic energy that would turn a simple request into a criminal record. She did not walk in to buy fuel or snacks. She entered with a desperate, singular demand that she treated as a matter of survival. This was not the silent night the employees expected. Instead, they found themselves at the center of a volatile Christmas freakout that would end in police intervention. The surveillance cameras rolled silently above, capturing every moment of the escalation. What began as a biological necessity quickly morphed into a confrontation involving screaming, spitting, and physical force. The subject of this incident was a woman identifying herself as Ally. She was not a local resident of Champaign, but a gig worker from Chicago who had traveled hours south. She worked as a driver for Uber, navigating the unfamiliar streets of a university town during the holiday lull. Gig drivers often face a unique set of challenges regarding basic human needs. Finding a public restroom while on the clock can be difficult, especially on holidays when most businesses are closed. The pressure of a full bladder, combined with the fatigue of the road, can shorten fuses. However, the law does not accept physiological urgency as a valid defense for battery or disorderly conduct. Ally entered the situation with a mindset that her immediate needs superseded the protocols of the private business she was entering. The other parties involved were the gas station employees, two individuals working a shift that no one particularly wants. A male clerk, referred to in the police interaction as the black guy, sat behind the counter. A female colleague was nearby, and another male employee was outside managing the trash. Retail workers are often the first line of defense against the unpredictable behavior of the general public. They are trained to manage transactions, not de-escalate volatile individuals' screaming demands. On this morning, the male clerk was arguably disengaged, reportedly looking at his phone when Ally arrived. In the service industry, this might be a customer service failure, but it is not a crime. The reaction it provoked, however, crossed the line of legality. The incident began the moment Ally crossed the threshold. According to her own recounting of events, she did not walk in and ask politely. She was already in a state of high distress. She later admitted to the responding officer, "I ran past to go to the bathroom." She saw the male clerk sitting down and immediately escalated her volume. "Hey, can I get the key?" she demanded, but the tone was not a question, it was a command. The clerk, perhaps startled or perhaps reacting to her aggression, did not immediately comply. This perceived delay triggered an explosive reaction. The ensuing scene fits the profile of a Uber driver freakout, where the stress of the job spills over onto bystanders. The verbal exchange deteriorated instantly. Ally acknowledged in her statement that she was loud. "What am I supposed to do? Whisper?" she justified later. But the volume was only part of the issue. The male clerk, feeling threatened by her rapid approach and shouting, stood up. He told her to step back. This is a critical moment in any confrontation. A property owner or their agent has the right to set boundaries for personal space. When a customer violates that space, the dynamic shifts from service to security. Ally did not step back. She pressed forward, fueled by her urgency and her anger at the delay. The situation escalated from a verbal store bathroom drama to physical contact. In her own words, captured on the officer's body-worn camera, Ally confessed to the escalation. "Yes, I did push his ass," she stated. She claimed this was in response to him walking up on her, yet she was the aggressor who had closed the distance to the counter. Illinois law is clear on this matter. Under the Illinois Criminal Code, specifically Statute 720, Section 5:12-3, a person commits battery if they intentionally make physical contact of an insulting or provoking nature. Pushing a clerk because they are not moving fast enough fits this definition. The employees reacted by denying her service and ordering her to leave. This is the prerogative of any private business. When an individual is asked to depart and refuses, they are technically committing criminal trespass. However, the interaction remained fluid and chaotic. The female employee, likely attempting to de-escalate the Karen public meltdown occurring in her store, eventually provided the restroom key. This was a tactical error in hindsight. By granting the request after the aggression, it validated the behavior. Ally went to the restroom, but the conflict did not end. The police had already been called. Officer response time was rapid. A single officer arrived on the scene, stepping into the aftermath of the shoutfest. His body camera began recording immediately, documenting the behavior of a woman who was still visibly agitated. The footage shows Ally outside the store, still vibrating with adrenaline. She was not silent. She was arguing with the air, with the situation, and soon, with the officer. She admitted, "I came in distress." Her definition of distress, however, looked to the outside observer like a public tantrum. She felt justified. The law saw a disruption of the peace. The officer's approach was clinical and detached. He needed to establish the facts of the crime. He asked for her version of events. Ally was more than willing to talk, but her admissions were damaging. She painted a picture of herself not as a victim, but as an instigator. "I ain't going to lie," she told the officer, a phrase that often precedes a confession. She detailed how she yelled. She detailed how she moved toward the clerk. She detailed the push. "I told, get the back," she said, recounting her command to the employee. "Don't put your hand on my neck," she claimed he did, though she also admitted, "I almost pulled out his back." The allegations of threats were mutual. Ally claimed the clerk threatened to kill her. He said, "Bitch, I'ma kill you," she reported. If true, the clerk could have faced charges for assault under Illinois Statute 700-20, Section 5, 12-1, which covers conduct that places another in reasonable apprehension of receiving a battery. However, the officer had to weigh the credibility of the parties. One person was a calm employee behind a counter. The other was a screaming woman who had just admitted to initiating physical contact. In retail worker harassment cases, the person causing the scene loses the benefit of the doubt. The officer moved to the investigation phase. He asked for identification. Ally refused. "No, I don't have nothing," she said. She claimed she left everything in her car. This is a common complication in police interactions. In Illinois, while you are not always required to carry ID on foot, failing to identify oneself when being detained for a suspected crime creates further legal jeopardy. It hinders the citation process and can lead to a physical arrest. Ally seemed to believe that because she was an Uber driver, her identity was irrelevant to the ugly-ass town she was visiting. She was mistaken. The dialogue between Ally and the officer highlights a fundamental misunderstanding of the law. She believed that her provocation, the clerk's alleged slowness or rudeness, justified her response. "He on a chair and I sitting down," she complained, angry that he was resting while she was in need. She felt entitled to immediate service. This mindset is the hallmark of an entitled customer who views service workers as automatons rather than people. When the machine didn't work fast enough, she kicked it. But unlike a machine, the clerk had rights. The officer went inside to view the security footage. This is standard procedure. Witness testimony is unreliable. Video is objective. The footage confirmed the employee's account. It showed Ally entering the frame with aggressive body language. It showed her shouting. It showed the physical contact. The video evidence stripped away her defense of self-defense. You cannot claim self-defense when you are the one advancing on a retreating party. The white guy witness who was taking out the trash also corroborated the timeline. The woman assault store employee narrative was cemented by digital evidence. When the officer returned, he carried a clipboard. The decision had been made. He was not there to mediate a customer service dispute. He was there to enforce the criminal code. He called Ally over. She was busy on her phone calling her sister, engaging in a secondary performance of victimhood. "They got me out here embarrassing," she told her sister, oblivious to the fact that her own actions caused the embarrassment. She described the situation as ghetto, a derogatory term she used to distance herself from the chaos she created. The legal charge was disorderly conduct. The officer cited specific statutes. The transcript captures him reading the formal notice, Section 720, CX5, 12-2. This appears to be a verbal slip or a specific local ordinance citation, but the behavior described falls squarely under the state's disorderly conduct statute, 720, Section 5, 26-1. This law prohibits any act performed in such an unreasonable manner as to alarm or disturb another and to provoke a breach of the peace. Screaming in a gas station and fighting employees fits this description perfectly. Allie's reaction to the citation was a mix of disbelief and renewed aggression. She began to cry, but the officer remained unmoved. "So, you're mad 'cause I'm crying," she accused. The officer corrected her immediately. "I'm not mad," he said. "I'm giving it to you straight." This interaction is typical in Karen calls police scenarios where the caller realizes they are the one in trouble. Tears are often used as a manipulation tactic to garner sympathy or deflect consequences. The officer, trained to focus on facts, did not take the bait. He presented her with a notice to appear. This is a written order to attend court. The date was set for the 21st of January, 2025, at 2 p.m. It was a mandatory appointment with the judicial system. She was being charged with a Class C misdemeanor. While not a felony, a conviction would result in a criminal record, fines, and potential probation. For a gig worker whose livelihood depends on background checks, this was a significant blow. The Christmas freakout had lasting professional consequences. In addition to the criminal charge, the officer issued a trespass notice. "You're also being trespassed from this gas station," he informed her, "permanently banned from the address." This is a civil administrative action that carries criminal weight if violated. If Allie were to return to 59 East Green Street, she would be arrested on site for criminal trespass to real property, a Class B misdemeanor. Private property rights in Illinois are robust. A business owner can ban anyone for any reason that is not discriminatory against a protected class. Banning someone for fighting staff is entirely legal. Allie's dismissal of the court date was telling. "My attorney will be there." "I don't have to court date," she scoffed. The officer advised her, "You need representation on your court date. If you don't show up, more reason for your..." He trailed off, but the implication was a warrant for her arrest. Failure to appear is a separate offense. Her arrogance regarding the legal process suggested she did not grasp the gravity of the situation. She viewed the citation as a nuisance, not a criminal indictment. The broader impact of such incidents is significant. For the employees, this was a traumatic start to a holiday. They were subjected to verbal abuse and physical intimidation simply for showing up to work. Retail worker abuse leads to burnout, high turnover, and mental health issues among service staff. The clerk who is pushed now has to go to work wondering if the next customer will be violent. It erodes the sense of safety that is essential for a functioning community. For the community of Champaign, this incident represents a drain on public resources. Police officers on Christmas morning should be patrolling neighborhoods or spending time with their families, not refereeing a public tantrum over a restroom key. The court system, already backlogged, must now process a case that never should have happened. Taxpayer dollars are spent on the officer's time, the prosecutor's time, and the judge's time, all because an adult could not control their temper. There is also a lesson here regarding the gig economy. Drivers are often pushed to the brink by long hours and a lack of infrastructure. However, this does not grant them immunity from the law. Companies like Uber and Lyft have strict community guidelines. A driver charged with violent offenses or disorderly conduct while working can be deactivated permanently. Allie's decision to fight for a key may have cost her the ability to drive for income entirely. The Uber driver freakout becomes a career-ending event. Systemically, this highlights the friction between public needs and private property. There is a shortage of public restrooms in America. Gas stations often fill this void, but they are not public parks. They are private enterprises. When a customer enters with an attitude of entitlement rather than gratitude, the social contract breaks down. Allie treated the restroom as a right. The store treated it as a privilege. This misalignment of expectations is the root of many modern retail conflicts. The legal analysis of the self-defense claim is worth revisiting. Allie repeatedly mentioned the clerk's behavior as justification. "He got to walking up on me," she said. In Illinois, the use of force in defense of person is only justified if a person reasonably believes that such conduct is necessary to defend against the imminent use of unlawful force. A clerk standing up or telling a customer to leave does not constitute imminent unlawful force. Words, no matter how rude or threatening, generally do not justify a physical battery in response. By initiating the contact, the push Allie became the legal aggressor. Her refusal to identify herself also warrants closer examination. While Illinois is not a stop and identify state in the traditional sense, the statute 725, Section 5, 107-14 allows an officer to stop a person in a public place for a reasonable period when the officer reasonably infers from the circumstances that the person is committing, is about to commit, or has committed an offense. Under these circumstances, the officer can demand the name and address of the person. Obstruction of identification can be a secondary charge. Ally was fortunate the officer simply proceeded with the information he eventually obtained rather than arresting her for obstruction. The video evidence she offered to show the officer was a double-edged sword. She believed her recording would vindicate her. "I got a recording talking out of there," she boasted. She thought capturing the clerk's yelling would prove he was the problem. This is a common fallacy in the smartphone era. People record their own crimes, believing that because they felt threatened, the video proves their innocence. Instead, it often provides the prosecution with clear audio of the defendant's disorderly conduct. The officer's disinterest in her video was not negligence. He had the store's objective surveillance footage. He didn't need her subjective, shaky cell phone video. The interaction concluded with Ally walking away, muttering insults, but legally bound by the citation. "I hope your attorney's there," the officer remarked, a final reminder of the reality she faced. The woman causing scene had been neutralized not by force, but by paperwork. The mundane nature of the punishment, a court date, contrasted sharply with the high drama of her entrance. What could have been done differently? On Ally's part, the answer is obvious. A polite entry, a request rather than a demand, and a willingness to wait would have yielded a restroom key and no criminal record. If denied, she could have simply left and found another station. There were likely other options within a mile. On the store's part, de-escalation training is always valuable, but it is difficult to critique employees for reacting defensively to someone screaming in their face. The clerk could have remained seated, but human instinct is to stand when threatened. For the public, this serves as a warning. The viral nature of Karen compilation videos has desensitized many to the real-world consequences of public meltdowns. We watch them for entertainment, but for the participants, they result in job loss, legal fees, and criminal records. The customer is always right. Maxim has no standing in a court of law. When you scream at a service worker, you are disturbing the peace. When you touch them, you are committing battery. When you refuse to leave, you are trespassing. The officer's conduct provides a model for professional enforcement. He did not raise his voice. He did not use force. He allowed Ally to vent her emotions while he focused on the legal elements. He separated the parties, gathered evidence, and issued the appropriate citation. He denied her the audience she craved and handed her the consequences she earned. In the era of high-visibility policing, this low-key handling of a public meltdown was textbook procedural justice. As the police cruiser pulled away and Ally returned to her vehicle, likely to finish her shift or drive back to Chicago, the Circle K returned to its quiet holiday rhythm. The employees likely shared the story with the next shift, a cautionary tale of the Christmas freakout that ruined their morning. The legal machinery began to turn, processing the paperwork that would summon Ally back to Champaign in January. The moment of rage had passed, but the legal